Good afternoon, everyone. I am John Ogier, the chairman of IPAN, the Intellectual Property Awareness Network. It is a great pleasure to be here with you all today and to welcome you to the IPAN for IP Council webinar on Brexit and intellectual property, where we will explore new opportunities for collaboration and cooperation in the post-Brexit IP landscape. Our goal today is not just to inform, but to foster dialogue between academics, policymakers, and the SME communities present with us today, from startup to scale up. We, of course, are also very proud to welcome a good number of students, especially from the University of Exeter, which is a corporate member of IPAN, and Nottingham Trent University, which has been a long-standing partner of IPAN. Thank you for joining us today. We all recognise that the changes brought about by Brexit influence entities, not only within the UK, but also entities based in the EU. This covers areas of IP law, such as in design rights and database rights, the exhaustion of rights, managing registration across the UK and EU as part of an international portfolio in line with a global marketing strategy. There is some uncertainty among stakeholders at all levels, from individual inventors to multinational corporations. We recognise that as the ground shifts, that there are uncertainties and challenges to be navigated. But we look ahead today with optimism and the keen objective of fostering an exciting new relationship with our counterparts in the EU. Over the decades, the relationship between the UK and the EU in intellectual property has been one of collaboration, growth, and harmonisation. Looking to the future, it is our view that the UK and EU-based academics, SME owners, and policymakers can continue to jointly and closely champion global IP standards and practices. Managing our decades-old spirit of collaboration and cooperation is key to ensuring that the next generation of creators, entrepreneurs, and professionals are well equipped to navigate the IP landscape, that the academic and research sectors can explore and chart a new future of law, creativity, and innovation, and that IP rights remain at the forefront of international trade and developments around artificial intelligence, particularly given the significant risks presented by infringement in the digital space and AI bias in the age of big data and automation. These are all priority areas on which IPAN is deeply engaged. IPAN brings together organisations and individuals from business, commerce, education, and the IP professionals in the UK, all committed to championing the importance and understanding of IP as a vital ingredient for innovation and success in businesses large and small. IPAN events, publications, and research activities aim to stimulate and extend debate about the role and value of IP protection in all its forms. We are constituted as a not-for-profit membership organisation, independent from any sector lobbying group, and committed to the principles of equality, diversity, and inclusion in all our activities, which span three key tracks: education, policy, and business. Our warmest welcome to you all for being with us today and joining us from both the UK and across the EU. And our thanks to the 4IP Council for their valued partnership on this initiative to explore the post-Brexit landscape and identify key areas for economic growth, policy development, and legal practice, as well as our academic scholarships. It is my great pleasure now to introduce you to our moderator for this afternoon's discussions, Claudia Tapia, President of the 4IP Council and Director of IPR Policy and Legal Academic Research at Ericsson, where she leads the Research IP Policies team and activities worldwide. Claudia is also a member of the editorial board of the Patent Law magazine and the Intellectual Property magazine, and our expert moderator for today. I now hand over to you, Claudia, and thank you.
Thank you, John, and welcome everyone. It's great to have you all here at this IPAN and 4IP Council webinar on Brexit and intellectual property. As you might know, 4IP Council is a non-for-profit research organization focused on the link between intellectual property and innovation. Our mission is to deliver empirical research on highly relevant topics. And we do so by collaborating with a variety of academics, experts, IP organizations, and other stakeholders. On our website, we provide plenty of free materials, for example, studies, guidelines, summaries of relevant papers, and recording of webinars like the one today. And we also produce easy to digest material, especially tailored for non-IP experts, small and medium enterprises, and startups. And on this note, we also collect input from small and medium enterprises to better understand their challenges regarding IP and develop proposals accordingly. We will share the link of our last survey in the chat, and we will really like it if welcome if you could fulfill it. It just takes a few minutes to do so. And I would like also to mention our new podcast. It's called IP Stories, where we interview entrepreneurs, inventors, and IP disseminators to learn about the stories behind intellectual property. You can follow us on X, LinkedIn, YouTube, and Instagram at 4IP Council. 4IP Council. And this is a great way to find out about IP news, resources, interviews, future webinars, you name it. But without further delay, it is my pleasure to introduce our speakers, to whom we are all most grateful for taking time from busy schedules to be with us today and share their insights and experiences in the discussion. First, we have Dr. Sabine Jacques, who is Senior Lecturer in Intellectual Property Law at the University of Liverpool. She joined the School of Law and Social Justice in 2023 as Senior Lecturer in Intellectual Property Law. Welcome, Sabine.
Thank you very much, and thank you for having me. Hi, everyone.
Great. Then also Dr. Francesca Mazzi, who is a lecturer in AI, Innovation and Law at Brunel University in London. Francesca is a qualified Italian lawyer and has a PhD in AI and IP within IPAN Innovation Society. Thank you for joining us, Francesca.
Thank you, Claudia, and good afternoon, everyone.
Mary White is an EU and Irish trademark attorney at Stops. Mary has extensive experience of trademark prosecution and the management and organization of client portfolios. Welcome, Mary.
Thank you very much, Claudia, and welcome, everyone.
And finally, Rachel Wilkinson-Duffy is partner in the Intellectual Property Department at Baker McKenzie's London's office. She's also the president of the Chartered Institute of Trademark Attorneys in the UK. Great to have you with us today, Rachel.
Thank you, Claudia. Good afternoon, everyone. It's really good to be here.
Excellent. Instead of doing long presentations, today's webinar will be rather an interactive session. I would like to encourage our audience to participate in the discussion by asking your question using the Q&A icon. But before we move to the Q&A part, I would love to hear your insights into the current landscape of the EU-UK intellectual property relationship. Rachel, would you like to start?
Thanks, Claudia. Yeah, happy to. So I guess the main change from an IP perspective, really, although there's been changes across the board, are primarily around trademarks and designs, which is actually my specialism. And I guess the challenge of Brexit is partly due to the great success of the EU systems in these two rights, which have been harmonized for many years. And in the UK, rights owners traditionally more commonly went with the EU routes as far as obtaining protection. So the challenge we've really been facing over the past few years was how to smoothly transition those rights over to the UK to ensure that rights holders didn't lose any effective priority dates or enforcement capabilities. And I mean, it will be really interesting to hear the views of other panelists, but my personal experience is that as challenging and in some ways very, very sad Brexit has been, this has actually been a positive experience. And it's been great to see how the UK's IPO and the EU IPO and everyone in the profession has really come together to ensure that that transition has gone as smoothly as it really could do. And as the current landscape appears to me, that transition is pretty much gone through and it feels much more stable. Of course, for SMEs, the challenge is to remember that they are two completely different systems, because it was harmonized for so many years that it's difficult to remember that you need to look at the UK as a separate area to obtain those rights. So enforcement, clearance, those kind of things continue to be a little bit more of a challenge now with the two separate systems, but it does feel very much that we've kind of come through the rough waves and things seem to be settling.
Thank you, Rachel, especially for this positive note after the sad news of Brexit. Who wants to continue? Maybe Mary?
Claudia. Well, yes, I have a little slide just to provide a brief summary of the current landscape, if Marta might just bring it up, because a lot has happened since Brexit. We recall that on the 1st of January 2021, there were pending EU oppositions based on UK grounds, and unfortunately, those grounds were no longer valid and those oppositions and cancellation actions fell away. So there were, I suppose, unexpected consequences for some some brand owners in that, and it took a little adjustment. But as Rachel has said, by and large, these transitional arrangements have been very good and have been very well thought through. One of the things that happened as well on the 1st of January 21 was all of the rights that had been in the EU were cloned into UK national marks. So we had EU marks cloned or created as a copy in the UK with the 009 before them, and international registrations designated Europe were given a new clone mark as well, designated with an 008 number at the start. So basically, to provide for legal continuity, the EU Withdrawal Act of 2018 allowed for retained EU law, so basically a clone of the law that was applicable at the time to persist and to provide, I suppose, a temporary continuity to allow the British Parliament to slowly decide what to keep and what to change. And this has been a very smooth and gradual transition. We've already seen over 1,000 pieces of EU law changed, revoked, or amended in some way. So this is happening without us even feeling it happen in some instances. And I guess for today's webinar, what we're really looking at is that the next step in the British government reasserting its sovereignty, in the UK reasserting its sovereignty, is going to come soon. On the 1st of January 2024, that next step is going to happen. And that is when the retained law, the retained EU law Revocation and Reform Act is going to come into effect. And that's important because it's going to revoke a long list of EU legislation. And one of the key outcomes from this is that higher courts in the UK will be able to depart from the retained domestic case law if it believes it to be the right decision. And they will be referring to the UK Trademarks Act of 1994 in order to look at that kind of way in which they might interpret things slightly differently in future. So it has been a very gradual and very smooth change so far. And then just to, I suppose, note that again, for EU rights holders, we have to be careful about these comparable marks, comparable designs that have been created. We have to be very careful to maintain our rights. So exactly as Rachel said, and making sure that come the 1st of January 24, that people put in place a UK address for service. And that comes following the Marco Polo case, for those of you who like to know the case law and where these things came from. So if we move on to the second slide, it's just a couple of very brief pointers, I suppose, as a result of these changes. These are what people need to know if you're running a small or a medium enterprise and you're keen to know what's coming up. So the big thing is that, as Rachel has rightly said, we have 2 different jurisdictions, and it's very important that those marks are maintained in both territories, and that enforcing your marks in different territories requires a bit more vigilance. And basically, to just give you one take home from today, it's that IP has been fairly settled, and there won't likely be sweeping changes. But it is important that brand owners note there will likely be divergences over time. And therefore, if we look at judgments like the advanced track one that came out recently, not to get carried away with worry, but more to just be vigilant and conscious that the UK courts may gradually diverge a little bit in terms of what they do over the coming years. And really in terms of one small immediate action for those who haven't already done so, the UK address for service requirement is fast approaching for EU rights holders of UK marks. It's really important to be aware of this. So that's kind of the landscape in a nutshell, if you like.
Thanks, Mary.
Thanks, Claudia.
I'm sorry, I need to stop here because we have such a long list to do. But I'm sure you will have an opportunity to bring those points. And I think it's so important to understand what do we need to pay attention to. So thanks a lot for starting this kind of discussion. And I would like to give the floor to Sabine in case that she has anything to add.
Thank you, Claudia, and thank you to my co-panelists for already setting the scene very, very clearly. And yes, it must have come as a real reassurance for businesses and creators to see that there has been this smooth transition, and that all the parties involved really came together to make sure that certain legal certainty prevailed during this transition phase. Now, I guess I'm a bit less optimistic about what might happen come January 2024, especially given the act that Mari was just mentioning. So the retained EU Law Act 2023 about revocation and reform. The fact that there will be this removal of the supremacy of EU law, but also that lower court can then refer cases to the higher court, such as the Court of Appeal, and the Court of Appeal can decide to just move away from the law as we understood it so far, will probably give a bit of of nervosity to businesses and creators, because we just don't know in terms of what will be the legal certainty come January. Hopefully it will be smooth as well, so either we'll decide to stay in line with EU case law, or if there's a departure for whatever reasons, then those reasons will be clearly stated so that there's no more open doors to more uncertainty in the future. But I guess what I would like to focus on right now in terms of an introductory question are 3 points in relation to the legal framework. So the first one, obviously, we have not implemented the recent copyright reform, and there have been discussions about also modernizing the CDPA in the UK. There was this idea of introducing a broader text and data mining exception that we know now has been cancelled for now. There's also discussions in the UK about remuneration, or the streaming inquiry. Some of you may be familiar with this, which again, there's not going to be a reform of the law as such, but there have been commitments for better data to be shared in order to understand how the money flows. So again, I guess right now, we still don't really know where we're going in terms of modernizing this copyright framework in light of new technologies and AI, obviously. Similarly, the EU is working on a design package, so there's going to be quite a number of changes in the future as well. It's my understanding that the IPO has also started conversations about modernizing the design framework over here, but we still don't really know what will be the trajectory taken. So once again, there we might see changes happening in the future as well, and we don't know in which direction either. And the third point is just really emphasizing what's happening in January, and this new constitutional tool, which for me is quite alarming in a certain way, especially for businesses and creators. Thank you.
Thanks, Sabine. Thanks for bringing us a different perspective. Maybe not as optimistic, but some will say maybe realistic. We will discuss today. And definitely, I think you raise a very important point in terms of these uncertainties, because for the business, it's such an important indicator of whether to trust or not a system. So we look forward to see the developments. And with that, I would like to give the floor to Francesca to hear her thoughts.
Thank you, Claudia. I think most of the things that were important to mention were mentioned already. I'm going to provide just a comment that concerns copyright and how I perceive the relationship between EU and UK at the moment, post-Brexit. So what I perceive is that, because we're talking about copyright, I'm going to make a comparison with a movie and an image. So the image is what is statically happening right now and how the relationship is, and the movie is what's going to happen next. So right now it's relatively settled. So I agree with the comment that Rachel made at the beginning, that the transition period seemed to have come to an end, and it is very clear what stayed in the legislation and what is not applicable anymore. Just to make an example, I thought about cable broadcasting, satellite broadcasting. It is clear that certain things like the country of origin principle and the mandatory managing of rights through collecting societies are not applicable anymore. They are not mandatory. Some other parts of the legislation, they are still the same, especially because there are international treaties that are harmonized, and they go beyond the relationship between EU and UK. So it seems to be a kind of a stable situation at the moment. That being said, what's happening next I believe that from what I am reading in the case law specifically, it shouldn't be perceived as something scary, even though uncertainties always create problems for SMEs, for example, specifically. But in the perspective of the future, what seems likely to happen is not a sudden change, and this comes from some wording of the case law that state very clearly what are the reasons why EU law is being used and is being applied despite Brexit in certain cases, and also by the fact that some movements that would determine a shift from previous approaches, European approaches, seem to be left to evidence and to public consultation, and seem to require a solid basis. So I would say that even though it is a movie that we still don't know the level of divergence, I don't think it should be a scary movie. Thank you.
I love this comparison with the movie and the picture, and also the involvement that we see gradually, maybe some changes, but not some extremes and not very quickly. So very interesting to hear, and thanks so much for sharing your preliminary thoughts. And while we are waiting for the questions of the audience, let me start with the following question. What are the main areas of uncertainty and the key opportunities, because we heard from both, that the UK and the EU states have ahead of them in shaping IP frameworks in the years ahead? This time, maybe we can start with Mary.
Thanks, Claudia. Well, I suppose the UK intellectual property law has been very harmonised with the EU traditionally, but going forward, it won't be necessarily wedded to that approach anymore. And common law systems, such as we have in Ireland and in the UK, have always been fundamentally a little at odds in terms of approach with the civil code system that we see in the in our European neighbours. And I guess there is a question now, as there's a possibility of slight divergence growing larger, will this put more emphasis on common law rights? And what will this mean, for rights holders? It's an interesting time.
It is indeed. Rachel.
Yeah, so I guess in the UK, one of the areas where there is a bit of uncertainty and it's expected to carry on for probably a few more years is around exhaustion of rights. And that is for those perhaps not as familiar with the concept, where within the borders of the EEA, you can freely move goods around, and those who buy branded products can resell them without it constituting infringement. And the UK has taken a bit of an interesting position during the transition out of the UK for Brexit, in the sense that they've effectively just extended that boundary to include the UK. But the EU, of course, has maintained its traditional borders and said, no, actual exhaustion is only within the EEA. So we do have this strange situation where there are the principles are the same, but businesses need to remember actually what you can do as far as with the UK when you're a rights owner, or indeed trying to move goods between different boundaries, that there's that distinction between the two systems. And there was quite an extensive consultation around this, and the overall conclusion was that it was a bit too difficult to decide whether it was a good idea to change that or not. So the UK decided to maintain the status quo, even though it does have this slightly inconsistent outcome. So I think that's one thing for SMEs in particular who do trade across parallel trade across borders should keep an eye out for. The other thing is, of course, the general, I mean, it's an interesting point that Mary said around, or was it Francesca? I'm sorry, I think both of you said something that touched on it, around the extent to which there is potentially going to be divergence between the two laws. And I think that comes down to the UK system is quite a mature intellectual property system, and within IP circles, I think there is a general consensus that to the extent that divergence is not necessary, that it won't happen. And if it does happen, I think the courts are very mindful of the need to have a stable IP environment. So I completely agree with the comments that were made around that I think, even though I agree that the new act coming through has been very scary for those looking at it. But the reality, I think, is probably going to be much more stable, and some uncertainty to come, but not too unexpected. And it will be a slow and steady process that we will probably be able to navigate with reasonable ease. And just one final point is also to touch on another, I'm keeping an optimistic theme with this, is that the news is that we should hope to see a memorandum of understanding with the EU, between the UK and EU, come through soon. And I know that's been in draft for some time, and so we're not quite there yet, but certainly in the UK, we're feeling very optimistic that that will go through, and that would definitely be seen as a real positive. So yeah, I'll end on that slightly optimistic note.
That's a good note for the audience. We look forward to see this MOU happening. Francesca, what are your thoughts on this? Are you in the more positive, less positive part?
Well, when you asked about the area of uncertainty and key opportunities for UK and EU, I'm actually thinking about, maybe I'm biased, but I'm thinking about artificial intelligence framework. First of all, because it is so related to IP on so many levels. I'm thinking about copyright, but I can also think about patent, and I think that here the intersections between IP and AI can be of particular interest for the legislation. Maybe it's not necessarily for like legislative amendment, but the AI framework, the AI regulation, and the way IP is going to be treated in relation to AI is going to have a huge impact on innovation. So I think both for UK and EU, this is a crucial moment, and there is no certain answer because the AI is taking an approach, a legislative initiative that is ongoing, so it's not confirmed yet. The UK launched 2 public consultation on AI and IP. Is not regulating AI now, but it has published many white papers or ethical frameworks. So it's trying to give a direction. So I think this is a huge opportunity for the relationship between the 2 jurisdictions, because one can say it's important to find a compromise and to create a level playing field where it's possible for companies to invest and is applicable for companies to invest, even though they might have different approaches. This could be something that is beneficial in the end because they can actually complement each other, but they can also focus on different stages of development. And IP plays a crucial role and is nothing clear yet. What is the position of copyrightability of AI-generated inventions or copyright infringement for AI training? It's not clear about AI-generated patents as well. So I think this is a huge framework for the future of IP, and in this sense, because of the commercial relations, and not only commercial, but the relations between the 2 jurisdictions, I would say it would be very important to find a good balance.
Mm-hmm.
Thank you.
Indeed, and before I give the floor to Sabine, we have received here a comment and question, and I will doubt, since this is related to the topic you brought, I hope, Sabine, you allow me to raise it, and maybe any of you can react to this. So I think it is a great pity that the UK is not able to participate in the development of the new EU AI Act. How likely is it that the UK's own AI decisions will be heavily influenced by AI companies, as arguably happens in the US, rather than by the interests of creators and users, which take greater prominence in the EU's approach?
Thank you. Thank you for the question. I believe that the focus of this question, because it talks about creators and users, is specifically talking about copyright and possibly about the management of copyrighted material processed by AI. Please correct me if I'm wrong, but if that is the case, I think that it's not necessarily true that will be heavily influenced by AI companies only, because there is an ongoing conversation on that, and the text and data mining exception was not adopted, maybe potentially also because of that. So I would say that the fact, I don't think the 2 parts of the question are connected, because the fact that they are not participating in the EU AI Act does not mean necessarily that the human rights first approach of the EU AI Act will be disregarded in the UK. I think they will try to find a compromise between the 2 different approaches.
Thank you. And I see Rachel and Mary nodding. So Vin, anything to add to this question or to the preliminary questions of regarding the areas of uncertainty and key opportunities that we have now?
Well, first I agree with Francesca. So that's my answer to the second question. But going back to the preliminary question about gaps and opportunities, well, definitely, obviously, the position that the UK will be taking in relation to AI and modernizing the IP framework is definitely something that remains a big discussion and something to follow. Going more into some of the specifics on some of the IP regimes, there's increasingly, it seems like, the emergence of new doctrines, for example, within copyright law, looking at exceptions and limitations. We see that more and more the intent of the user is considered as one factor, and here perhaps this is quite new within the EU framework to try to understand, well, what do we mean by intent? How do we appreciate it? And this in addition to the fact that now there's more obligation falling onto large platforms, and they have to also enforce and make decisions in particular instances how they appreciate intent is quite a challenge for them. So this is a topic that where there could be collaborations in terms of trying to understand what we mean. So here I have in mind, for example, the Meta Oversight Board, when they have to deal with cases such as parodies or satires, and how do you define the intent of the user, and that the users cannot get away by saying, I was just joking, type of defense is something that is of concern to corporations as well. So I'm sure there will be discussions on this. The second point is about IP accumulation as well as questions of overlap. We see that as IP develops, it's the scope is broader, and the boundaries perhaps between IP rights is starting to erode. In which case, of this question of how do we deal with IP accumulation is also one of importance, and it will be nice to see collaboration in how we deal with these questions. We can think immediately about work of applied arts, which can be dealt with under copyright and under design, and with now the design package, which seeks to modernize the EU framework by introducing more defenses as well. Well, there are quite important questions there to be looked at, but also in terms of specific doctrines that traditionally belong to one IP rights that suddenly are being imported to another IP right. So again, looking at this design package and exceptions, we see that, for example, the proposed new parody exception in design law subjects this exception to the honest practice provision, which we know from trademark law. We also see an overlap between a trademark and copyright in terms of the doctrine that's being imported. Here we see that it's quite, since the Angela Levola case, we see that there's this fixation requirement in EU law that's emerging with terms that that make us think about what we know from the trademark system. Sufficient precision and objectivity brings in mind segment, for example. And here, UK law has a long tradition of applying the fixation requirements. So here there's another possibility for collaboration in terms of opportunities in learning about the development of this requirement. And my final point will be about the increased importance in terms of trying to strike a balance between IP and fundamental rights, especially the right to freedom of expression. So in the last couple of years, we've seen a number of cases heading to the Court of Justice of the European Union in trying to provide guidance in how do we strike this balance. And obviously, most national legislators have struck this balance internally within the law itself. So now that judges are expected to also strike a balance in particular cases requires further clarification. So this is another area which will become increasingly important in the future cases, and which is an area where there are gaps and opportunities.
Thank you, Sabine. And we received also another question regarding more practical point of view. But before addressing that, I think it's important that we start looking at all these challenges and opportunities. I mean, we have heard from all of you and the last statements also from Sabine how important it is to have, collaboration and this balance between PA fundamental rights. But I'm thinking, what do these challenges and opportunities mean for legal academics, from legal practitioners, from policymakers? Because maybe we have all of them listening, and maybe here we can start setting the helping them in this path. So maybe we start this time with Francesca.
Thank you, Claudia. So I will start with policymakers. In relation to AI and IP, I think policymakers are facing very difficult choices and dilemmas that are almost ethical, difficult trade-offs to maintain a bargain between all the stakeholders involved, and especially pointing towards the direction for which copyright, for example, was conceived in the first place. So actually incentivizing creative works, creativity, which is whether it's human or not, but how to maintain this balance between rewarding inventors and artists, but at the same time not monopolizing for example, works that are produced with AI, because the problem is that there is a huge dilemma in how to make sure that still investments should be made, because it's still creativity and innovation, but then is not desirable to concentrate the whole creative power in AI, and the risk is to stifle human creativity. So there are different interests at stake, and it's difficult to find a balance when it comes to AI and IP, especially again for what concerns copyright in this case. And I guess one of the good things that I've seen with my research is that it's very important to have multidisciplinary collaborations and multiple perspectives when drafting regulations. And because it's maybe, I mean, it is a very basic thing to say, but having on the table different minds that come from different background and that might be impacted by this kind of legislative amendments, if any, can allow to see the scenarios, the various what if. So I think more than ever in relation to AI and IP, it's important to have multidisciplinarity. And then moving to legal practitioners, I think one of the problem is the lack of precedent in relation to AI and IP. And now with patent, we have the Dabus case. So there have been some rejections from IP offices and sentences as well that determine a certain stand of the court. And for what concerns copyright, actually is not very flourishing, at least here. There are some cases in the US. So I think the lack of precedents and gives some uncertainty for legal practitioners. So I guess one of the things is trying to understand what is the direction of the policymaking through white papers, if it's not legislation, and try to understand how to apply that kind of legislation to the that kind of direction to the specific case. But it's also true that when it comes to copyright infringement is something that probably needs to come from the legislative power. And for legal academics, I guess the contribution that academia can give to this debate comes from a very industrial, specific approach. So I would say empirical data and studying very well the effect that a certain measure can have measure on IP can have on the sector can allow to provide sensitive information that can help building policy making afterwards. So I think this would be my idea. And to conclude, the opportunity would be, I think, to you to create the best possible framework for AI and IP and the possible IP approach to AI, so that one can maximize the positive impact of IP and actually maybe overcoming the shortcomings. Thank you.
Thanks, Francesca. We have quite some questions, so I'm going to really ask you to be very short if you have anything to add, so that we can cover as many questions as you have. So from any of you, maybe Sabine, Rachel, Mary, just very, very short thoughts that have not been included with Francesca's answer, please.
Yeah, sure. So obviously, I support what Francesca has been saying so far. I think I would like to emphasize the importance of, all of this being an open and collaborative effort in order to deal with these challenges, because the questions that we have in relation to AI and IP, well, it all goes back to the core of our IP systems. So, who is the creator, who is the inventor? It's all bringing back the justification for having an IP system with unprecedented challenges. So it really requires all of us, including obviously industrial actors, to get together and to have these discussions in order to adapt the framework.
Thank you. Rachel, Mary, anything to add?
I would just make more of a, and this is perhaps a wishy-washy statement, but talking about challenges and opportunities, they really are in many ways the same thing. And most of it all comes down to whether harmonization is really a positive thing or not. And while there is definitely a strong view in the IP world that harmonization is generally a good thing, and I think that the UK profession and users and business will continue to push for that where it's appropriate. I would say that there are lots of challenges in some use an example.
You have some interference. I was wondering whether you have a phone next to you or something, which it's, if so.
I do. Apologies. Is that better?
Yes, go ahead.
My apologies. Concern. I think the general consensus is that in the vast majority of cases, this is absolutely positive, and it's something that the industry will be pushing to continue with. But I think it's also worth looking at the opportunities that divergence can sometimes offer. And to use a non-EU specific example, if you look at the Madrid system at WIPO, one thing that is quite up for debate at the moment was a paper that was put forward that talks about introducing greater flexibilities for the members. So to say dependency could vary depending on whether a jurisdiction wanted to have no dependency or a 3-year dependency. And there's a lot of discussion as to whether that's a positive thing. And I think it's open for debate, and we have a lot to see still as to how that really works. And ultimately, if I can put a challenge out there for those who are in the sort of policy making space or in business, to keep that discussion going.
Right, so you're missing the challenge. Go ahead. Now we can hear you. From the policy, what is the challenge you're going to throw to them? Unfortunately, it's breaking. May I suggest that you write it down, and then I will read it. And then in the meantime, I'm going to raise the next question to the panel, which we receive. It's kind of related and not related, which is that the unified patent court system. So the question is, what is the view that the panel has on the Unified Patent Court first few months of operation and what it means for businesses? So I'm not sure if any of you has a view on it that you would like to share with us. See silence. Mary, do you have any thoughts? You can also say no comments, and then we can go to the next one. But since it was great.
Sure. Well, I mean, I'm a trademark and design specialist myself rather than a patent attorney. So I'll defer entirely to those with more experience in that field. But I suppose the big thing would be that it's going to be more cost efficient really for the users of the system. And I think there's a good deal of excitement about it coming on stream, Claudia. So we're very excited about it and looking forward to it. But perhaps Francesca might have more on that one than I would, or Rachel, or.
Well, if any of you have thoughts, please, we can discuss this. From my side, I think all new systems require always a little bit of time. So we have seen in this case, the organization was not as expected at the beginning, but we have seen it, I think, in all the systems that have been created, that the first months it's not always clear, and learning from the mistakes, the systems can get better and better. And for that, I don't know, Rachel, if you would like to, did you have the opportunity to write? Oh, here we go. So here we have the challenge for the policymakers, but also SMEs and business generally. Spot opportunities for where divergence might actually be a positive. For example, because of inherent variations in different markets, cultures, etc. Harmonization is generally a positive thing, but let's try to find positives where we can. Thank you very much, Rachel. Okay, I'm gonna look at the next question, which is there any post-Brexit topic which is worth to discuss in an academic dissertation which compares UK and EU trademark law? So someone is looking for a topic. Anything that comes to your mind?
I'll hop in on that, Claudia. At the moment, I think we are only just seeing some early shoots, if you like, of people's enthusiasm. So there is a recent decision, the advanced track decision, where there was a good level of personal opine, if you like, on the importance of this upcoming date of the 1st of January 24. But in reality, whilst it was an opportunity to compare, sort of an EU approach and a UK approach, the decision in the case was going to be the same, and that referred to a Google AdWords dispute and whether or not, there was a similarity between an AdWord and somebody's trademark. So there's an interesting case there if you wish to look at the advanced track case, but it's very preliminary. I think that it will be down the line that we see more of this. So I would be watching for decisions coming out of UK higher courts over the next while. It could be some time before we see a lot of them, but perhaps watch the likes of Lord Justice Arnold, who has strong views and perhaps will come out with some interesting judgments in due course. Very exciting time ahead in terms of academics and the ability to compare and contrast as decisions come out. But until after the RIULA and at the start of 2024, I think at the moment it has still stayed quite close. So exciting times in early 24 for this question.
Thank you. Indeed, very exciting times. And then a question I have is, are there any emerging trends or areas of research focusing on intellectual property in the UK post-Brexit that scholars and students should be aware of? That's very aligned with your question. So maybe Francesca, any thoughts on this? Emerging trends? You need to unmute.
Sorry, I was reading the last. Sorry, can you repeat the?
Sure, of course. My question, because we get all the messages and all things interactive,
Yes.
not always easy to follow. The question is, are there any emerging trends or areas of research focusing on intellectual property in the UK post-Brexit that scholars and students should be aware of?
Thank you. My perspective on the areas of research that can be relevant or interest are, in relation to IP, are mostly related to sustainability, because it has a strong impact on practice as well, meaning that studying the relationship between IP and sustainability has an impact in trying to find metrics and indicators, and has a value for companies as well. It helps an ongoing discourse on how to find gaps in existing literatures, because it's an interdisciplinary area which is not new at all, and it depends. For example, for trademarks, it's been a thing for a long time, but it's not the same for all IP rights. So I think I would say definitely IP and sustainability, and I would say that what is seen as very important is an empirical approach. So going and various sectors, because sustainability is such a huge topic with tons of indicators. In a life cycle of one IP right, you have to go very specific, and I think this is one kind of research that is emerging now with all the conversation on ESG and SDGs. So I think that's something valuable. Thank you.
Thank you. Sabine, if you could give us 1 minute answer to that, maybe you have something to add?
Yeah, so in addition to sustainability ethics, as well as part of this area, obviously the interplay with fundamental rights, and again how we're striking this balance between IP rights and fundamental rights, but also thinking about goals of circular economy and which directions the UK is taking in this area. There are more and more discussions, especially given the cases that are coming from the EU. And obviously questions of IP accumulations, there's more and more written on this, and this is increasingly important, and it's unlikely to go away.
Great topics, thank you. You all have raised such important points, and in the interest of time, because I see we only have 4 minutes, I like to invite each of you to contribute one thought, but literally 1 minute top, each of you. Let's start with Mary.
Thank you very much for kind of offering me the floor. It's hard to pick just one thing, but I feel as if while we've really been living through seismic political and social upheaval, the actual needs of companies have not changed, and they are very much evergreen. So to maintain timely, legally sound, reliable and high value IPR, the key point is to remember there are now 2 separate jurisdictions, which means more time, more knowledge and more budget. And really attention to detail in terms of the developments we might see in the UK law, so we don't assume that we will have an EU style answer to a UK question.
Thanks. Sabine.
Thank you. Well, I'm going to close with what I started with, which is the importance of having clarity. So yes, it's been smooth so far. It may be smooth after January as well, but there will be divergences as well. And in that case, we need clarity for everyone. So it's interesting times for sure, but the importance is clarity, and perhaps not diverging with EU case law just obviously in one go, but if there are reasons to do so, to explain these reasons clearly.
And this clarity, this connects me a lot with the topic of collaboration that we have heard a lot today. Francesca, final thoughts.
Thank you, Claudia. I think I would like to say that Brexit should not necessarily stop us from thinking at a regional level, and even eventual differences in jurisdictions might end up in a situation where an IP strategy can actually use some differences and try to complement what is missing in one with another, and try to think about it in a holistic way. And yes, of course, this is a very positive perspective, and there is also the compliance aspect, which is very important, and to try to think about it in advance as part of the IP strategy as well. Thank you.
Thank you. Rachel.
Thanks, Claudia. Can you hear me okay?
We can. So far, we can.
Okay. Great, sorry. So since only one thought, I'm going to try and bring together what Francesca and Mary said and build one thing. It's not just necessarily more time, budget, and complexity. There's also the potential that, yes, it's a European market, and bringing the EU and UK market together is very important for a lot of businesses. But when you're looking at it particularly from a trademark perspective, don't always assume that what's going to be available and free to use and enforce in one is going to be the same for another. One thing we're already seeing before the registry is it's not divergence in the strict sense, because there was always a difference in opinion between registries, but sometimes what might be available may not be available in the other jurisdiction and vice versa. So just think about that. And as Mary said, look ahead. If you want to treat it as one market, you do need a bit more time and probably a bit more budget and complexity around making sure you have something that works in both. Not saying it comes up a lot, but it's something you need to think about. Thank you.
Thank you. Great points, all of you. And on that note, we conclude this virtual panel event, which IPAN and 4IP Council have been delighted to co-host. Please do look out for our event report and the recording of today's event, which we shall post in our websites and our social media platforms. John, may I invite you now to say a few words in closing?
Thank you, Claudia. I hope you all found today's discussions to be engaging and enlightening. I certainly did. Our warmest thanks and appreciation to all our speakers who have taken so much time out of busy schedules to be with us here today. There is, of course, much, much more we can say about this topic, and many new developments and opportunities for us to explore in future discussions. IPAN wishes to express its appreciation to 4IP Council for the partnership on today's events, and to you, Dr. Claudia, for your expert moderation of this excellent discussion. Of course, we are immensely grateful to all our speakers, Dr. Sabine, Dr. Francesca, Mary, and Rachel, for giving so generously of your expertise and insights. And of course, to the entrepreneurs who are starting up and scaling up, and to the lawyers, students, academics, and business owners, thank you for all joining us. We look forward to seeing you all again at a future event, and many thanks on behalf of the Intellectual Property Awareness Network and 4IP Council. Thank you.
Thank you. Thanks, everyone.